We've been listening to your TikTok and your YouTube comments. So today I want to try to answer some of the questions that you guys have been asking. The first one is probate worth it when you have a small estate? Well, it depends on how small the estate is. If we're talking maybe 10,000 or less, then it's probably not worth it, because I can tell you a probate, at least where we are, is going to run you between $5,000 and $8,000. And so it may not be worth it to pay an attorney $5,000 to split $5,000 with your family. But if it's under $50,000, you might look at your state laws, and they might have what's called a small estate affidavit, which might allow you to distribute assets without having to go through the probate process. Does a spouse automatically become your power of attorney? And the answer is, well, no. A lot of times people will let the spouse make decisions for you, but if it comes to financial decisions and sometimes even medical decisions, there needs to be a power of attorney in place. So for finances, it would be a durable power of attorney or a financial power of attorney. For healthcare, it will be a healthcare power of attorney. I can tell you some of the cell companies several years ago that were putting their accounts in only the husband's name, and then when the husband passed away or when the husband was incapacitated, they would not let the wife have any access to those accounts, and it created a lot of trouble. So even if you're spouses, you need to make sure that you have power of attorneys in place, naming each other as each other's power of attorney. I want to set up a trust for my family, but I don't know where to start. Well, the first thing I always tell people is educate yourself. Watch videos like the one you're doing right now. Go back to our channel and see what else we have to offer. Get books from Amazon. We have links to some books there as well that you can look at and educate yourself on the process. And when you're ready, book an appointment with 2 or 3 attorneys, 2 or 3 estate planning attorneys, and make sure you are comfortable with them, because you need to build a relationship with this attorney. Because like I've always said, once you have your estate plan in place, it's not just done. You need to amend it, review it on an annual basis. And so you want to have a relationship with that attorney, somebody who you can trust moving forward. So this is another question from TikTok. What happens when you have 5 people listed on the deed or the transfer on death deed for a piece of property, and 4 of the children want to sell the property and 1 of them doesn't? Well, if the title is already in your name, in the names of the 5 children, because your parent did a transfer on death deed possibly, or maybe you received it from a probate and the probate court put it in all 5 of your names, well, in that case, if there's one person who does not want to do anything, in most states, you can do what's called a petition to partition. And basically, you're asking the court for permission to sell the property. And then it's up to that one particular brother or sister to either get a mortgage to buy everybody else out, or the court's going to sell it. What happens if you list somebody in your last will and testament as your executor, and they either can't serve or they just don't want to serve? This actually comes up on a regular basis, where a lot of times families don't communicate. So somebody may name their child or maybe a best friend as their executor in their last will, but they don't ever talk to that person and let them know. Or maybe when the time comes and it's their job to administer the estate, they see the rest of the family fighting and they don't want any part of that. And that's okay. If you don't want to serve, you don't have to. Just because somebody has named you as an executor doesn't mean you have to serve in that role. What qualifies as a small estate? Well, again, it depends on where you live. In some states, like where we practice law, it's under $50,000. So usually if the estate is under $50,000, you can use what's called a small estate affidavit to transfer bank accounts, financial accounts. Now, that's the law, but I will tell you, in practice, a lot of times, some banks, especially if families are fighting, will not want you to use a small estate affidavit. Instead, they will require you to go to court because they don't want to get in trouble for giving the money to the wrong person. But in general, a small estate is usually under $50,000.